Hi, this is Josh Blackman. I am the president of the Harlan Institute, and welcome to the 2022 Harlan Institute Ashbrook Virtual Supreme Court competition. This year, we are arguing the case of Students for Fair Admission versus the University of North Carolina. Representing the petitioners in the semifinal round are Kevin Basili and Maxwell Steinberg, and representing the respondents are Colin Young and Aaron Strauss from the Exeter Academy in New Hampshire. All right, without any further ado, petitioners, begin whenever you're ready. Go ahead.
Mr. Chief Justice, and may it please the court. The 14th Amendment is clear. There is no place for state racial discrimination in this country. Racial preferences granted by universities violate this principle, and Grutter was grievously wrong, and it should be overruled notwithstanding the principle of stare decisis. State affirmative action cannot survive strict scrutiny, and it must be found unconstitutional.
As it stands today, the law makes clear the universities must show a compelling interest in narrowly tailored policies in order to justify racial affirmative action. Under Grutter, an indeterminate critical mass of minority students is such a compelling interest that it justifies surrender to racial discrimination.
Would the court like a brief statement of the facts, or shall we proceed with our argument?
Please, go ahead.
UNC, a highly competitive public university, makes use of a holistic admissions program to distinguish between the roughly 60,000 applications it receives a year. The record amply demonstrates that the school uses a student's race and ethnicity throughout the admissions procedure and is a crucial factor in the eventual decision.
Admissions is a zero-sum game. An advantage to one student necessarily disadvantages another. As a result, race and ethnicity explain 1.2% of the in-state admissions decisions at UNC and 5.1% of those out-of-state decisions. Continuing
to our argument, the 14th Amendment prohibits state affirmative action such as that at UNC. Beginning with the text of the amendment, it decrees that no state shall deprive any person under its jurisdiction of the equal protection of the laws. The definition of equal, as understood at the time of the amendment's passage, is of the same extent, measure, or degree when compared, or alternatively, not inferior or superior. This is contradictory to affirmative action, a system in which students of some races are given superior treatment to students of other races.
All right, let me, if I can jump in, please, Counselor. Can you please talk about some of the legislation that was passed by Congress in the 1860s and how those sorts of laws have a bearing on this case?
Yes, Your Honor. So the 14th Amendment was passed in the context of Jim Crow, black codes, and rampant segregation and racial injustice. At the time of its passage, or around the time of its passage, Congress also passed the Freedmen's Bureau Act in order to address some of these hardships and injustices. But I would like to point out, it did not extend its benefits only to freed Black slaves, but rather broadly to refugees and freedmen, giving.
Well, that's true. That's true with the Freedmen's Bureau Act, but there was some legislation that specifically referenced color, like race. I mean, there was some legislation that made that reference.
Yes, Your Honor. The Civil Rights Act passed around that time referenced color. The quote is what the Civil Rights Act was doing at the time was bringing the rights of the freed Black men and women up to that of white persons, as it states in its text. And again, this was not in order to create a new racial hierarchy or permit other.
But couldn't the same sort of reasoning, and this may be for your partner, the same sort of reasoning be extended to using affirmative action today to help groups that are disadvantaged? Couldn't a similar reasoning be extended?
In the Civil Rights Act context, the law amounted to treating all races equally in practice. The affirmative action proposal of UNC, their policy, amounts to treating people on the basis of race differently. Additionally, if the court does not believe that, does not agree with us that the Civil Rights Act and Freedmen's Bureau were race neutral, both facially and in effect, they still serve a different remedial interest than respondents advanced before the court today.
Well, let me ask this question. Is the UNC policy about remediation?
They certainly do not advance, the respondents do not advance that interest in their brief. And additionally, and it's the reason they don't is because they cannot. The last time UNC discriminated on the basis of race was in the 1960s, I believe. That's a lot different than the context just after, during Reconstruction, just after the system of institutionalized slavery that had existed for generations in this country. It's much different than that. So the remedial interest no longer applies.
Let me ask Kevin a question, if I might. Let's say we give you everything you want, right? We overrule Grutter, we overrule Bakke, and we say that universities cannot do blank, right? Help us write the opinion. What would the opinion say? Going forward, universities cannot do X. What do we fill in the blank with that?
Your Honor, we would recommend you fill in the blank as universities may not discriminate or distinguish on the basis of race in determining which students to admit or reject from their student body.
Okay, so, universities ask for essays. People fill out essays as part of the application, the personal statement, and then some students discuss their race in their personal statements. Are the universities required to just close their eyes and not even read it or ignore it?
Your Honor, the university should definitely read the personal statements. And if an applicant, in talking about their race, is using that to help explain who they are and why they are a good fit for the university, of course, may consider the applicant's essay.
Isn't that exactly what's going on now? Isn't that what Grutter said? Use race as one of many factors. I mean, how is that different than what Grutter permits?
Under Grutter, universities are using race in a box checking way. What we're proposing.
No, I know that's what you say, but Grutter said race uses one of many factors. Why can't we just say maybe UNC is not complying with Grutter? Maybe we can just keep Grutter and say you're not complying with it because you're doing the box checking thing.
We think that we should not the court should not keep Grutter because Grutter is unworkable for lower courts, which are not able to evaluate the social science evidence that amounts to feelings of racial isolation and individuals being a spokesperson.
I want to go back to this point though. How if you're, I asked you to fill in the blank. You said you cannot discriminate on the basis of race, period. Well, then why would they consider it all when a person talks about race in an essay?
Your Honor.
Sorry.
Red tie, go ahead.
Your Honor, in the essays, universities may not discriminate on race on this basis. All the applicants are going to write different essays talking about different elements of themselves and trying to explain why they're a good fit for the university. What we believe is impermissible is universities using the applicant's race as a factor. So that would include giving a preference for essays that talk about race over essays that don't talk about race.
Well, I mean, but again, it's a zero-sum game. I'm with you. Admissions is a zero-sum game. What then does the essay do if it's not giving a benefit? In other words, what role will the essay actually play?
The essay could be a means of conveying how race was an experiential component in these students' lives, not in just.
Isn't that making a decision based on the person's race? In other words, but for their race, they would not have had this experience.
It's a position based on experience, not on race, because people of the same race can have a variety of different experiences. A wealthy Black student who goes to private school is a lot different than a Black student who grows up in poverty in rural Nebraska, for example.
All right, so let me ask. I'm sorry, Justice Gustin, if you want to jump in, I didn't want to dominate the argument. Okay, so let me ask a follow-up question then, right? Let's say we give you everything you want. We overrule Grutter, we overrule Bakke, and in 5 years, you come back to us and the university says, look, we tried everything. We tried socioeconomic stats, we tried everything. And our classes are lily white, a bunch of white kids, a bunch of Asian kids, right? That's all we have. And a campus of thousands of people, we only have, a few dozen African-American students. Do you still take your position that race can never have any factor in admissions? Is that still your position?
Yes, Your Honor. Even if the effect of race-neutral admissions policies is to produce producing a campus that does not have racial diversity, that would still be acceptable. Under the view that the Constitution demands colorblindness of universities, this could be a consequence and would have to be accepted.
And you'd be okay with that?
Yes. However, the record bears out that in the numerous race-neutral alternatives we propose for UNC, amply suggest that the decline in underrepresented minority admission will be very, very slight. And there's no evidence to suggest that Michigan state schools, California state schools are not diverse.
We're short on time. Let's talk about stare decisis for a minute. So we just had Dobbs last year, and Dobbs had this, there's the multi-factor test for stare decisis. How would the reliance interests in this case compare to the reliance interests in Dobbs?
Your Honor, there are no solid reliance interests in this case. Grutter, in its 25-year time frame for the end of affirmative action, explained or should have given warning to the universities that they need to move towards race-neutral alternatives. If the universities cannot have moved to race-neutral alternatives in that time, affirmative action's inability to eliminate its own necessity is proof of its failure, thus demonstrating that it should not pass strict scrutiny.
Okay. All right. Thank you, counsel. I think your time's actually just sped up, so that worked well. Respondents, you have 15 minutes. Please come on camera and begin whenever you are ready.
Yes, Your Honor. Mr. Chief Justice, and may it please the court. The University of North Carolina is the oldest public university in the nation. And throughout its history, the university's admissions programs, like those of most universities in the nation, have consistently hurt African-American students who were barred from the school altogether until relatively recently. This history gives the university an understanding about the importance of racial diversity in the institutions of higher learning. To this end, the university uses a holistic admissions process that includes race as a factor. Although Bakke and Grutter correctly found that race-conscious admissions programs like UNC's are constitutional, we believe its rationale was erroneous and should be overruled. Bakke took the unprecedented and indefensible step of applying strict scrutiny to race-conscious admissions programs that benefit minority groups. Applying strict scrutiny to this case runs flatly in the face of this court's precedents, as well as the purpose of strict scrutiny. And although Grutter was correct in saying that race-conscious admissions policies like UNC's are permissible even under strict scrutiny, it was wrong to apply strict scrutiny in the first place.
In Caroline products, this court found that certain laws, namely those which interfere with the electoral process or other fundamental rights or national, religious, or racial minorities, who are discrete and insular minorities, which tends to seriously curtail the operation of political processes. Indeed, besides the affirmative action context, every single case in which this court has applied strict scrutiny has been to protect a fundamental right or to protect a discrete and insular minority. Bakke's and petitioners' use of strict scrutiny to protect the majority at the expense of the minority group is misguided.
Nor does stare decisis save Bakke's rationale. All of stare decisis factors, which the court identified in Dobbs v. Jackson, point towards replacing Bakke's rationale with respondents' proposed alternatives. Respondent proposes that instead of strict scrutiny, this court apply intermediate scrutiny or a historical standard as it recently did in Bruin. Under either standard, respondent prevails.
The petitioner today has a high burden to prove with regards to the historical record. They must prove that race may never be used.
I think we may have a glitch on our end. Are you representing petitioners or respondents here?
We're presenting We're saying that although Bakke is correct in allowing for affirmative action, it was incorrect to apply strict scrutiny to the affirmative action context and should have been applied intermediate scrutiny instead.
We're also using that historical analysis as recently applied in Bruin, maybe in order.
So you want to overrule Bakke, but not Grutter?
We would like to see both Bakke and Grutter overruled in part. So their rationale is overruled, but their results and decisions held.
But this is about race-based admissions. Race is clearly a protected class that we apply strict scrutiny to.
Yes, Your Honor. We believe that the arguments used in Grutter and Bakke to say that race should be considered discriminating against majority groups should be considered a strict scrutiny classification are not convincing. So we have several reasons for this.
First, now I got you. So what you're saying is, are you drawing a distinction? That's so creative. Okay, now I got you. Are you drawing a distinction between racial classifications that harm minorities and racial classifications that help minorities?
Precisely, Your Honor.
So which would you apply with strict scrutiny and which would you apply with intermediate scrutiny? Just so I understand your position.
We believe that racial classifications which harm minorities, especially discrete and insular minorities, should be treated with strict scrutiny, and those that do not harm minorities should be treated with intermediate scrutiny.
And I mean, this position has been advocated, I think it's by Justice Stevens, if memory serves.
Yes, Your Honor. Yes.
The Supreme Court's never accepted it. So you're actually asking us to adopt one of Justice Stevens's positions to support your argument. Is that right?
Actually, Your Honor, the Supreme Court at one point did accept this in a case called FCC, where it allowed for government contractors affirmative action.
Metro Media?
Yes, Your Honor.
That's a very fractured opinion, though, if my memory serves, wasn't it?
Yes, Your Honor.
So I don't know if there was a solid 5-vote majority there, but okay, let's just okay. So let me actually just sort of tease out your position. Your friends on the other side. I'm sorry, I for a second I thought you were saying overrule Groot. I'm like, wait a minute, aren't they on the same side? Then I figured out what your argument you were making. No, it's very creative. So your friends on the other side argue that admissions is a zero-sum game, and in a way it is, right? If you have 1,000 seats in a freshman class, admitting student A because of his race, and student B doesn't get the same benefits as a different race. How do you square this? There's always a plus and a minus whenever you use race. How do you distinguish between your strict scrutiny standard versus the intermediate scrutiny standard?
Your Honor, that's exactly why we believe that intermediate scrutiny here is necessary. There are still disparities in higher education that are a result of discrimination shown by the numerous stats that we've referenced in our brief. Secondly, Your Honor, petitioner is contending that race-based admissions is sometimes unacceptable. The contention in today's court is whether they're always acceptable, as whether or not they're always acceptable, as shown by the historical record, clearly stating the intentions of the 14th Amendment's framers. They said that all persons within the jurisdiction of the United States shall have the same rights as are enjoyed by white citizens. Senator Trumbull, who was instrumental to crafting the Reconstruction era amendments, said that the law for the relief of the persons who need the relief, not for the relief of those who have the right already. The Freedmen's Bureau Act directly gave benefits to Black individuals in social and educational contexts.
Sorry to interrupt you. Your friend the other said the Freedmen's Bureau Act was not about giving it to people on the basis of race, it was about giving people to the benefit of former enslaved status. How do you respond to that?
Your Honor, the Freedmen's Bureau Act echoed the petitioner today. In fact, many of the arguments which the opponents of the Freedmen's Bureau made are echoed by the petitioner today. President Johnson, for instance, who vetoed the bill, accused it of being founded for one class or color of people more than another. But the framers of the Freedmen's Bureau Act, who would go on to frame the 14th Amendment itself, responded that the very object of the bill is to break down discrimination between whites and Blacks and to make possible the amelioration of the condition of the colored people. It is undoubtedly clear that most...
I'm sorry, there might be a slight delay. That's why we're sort of talking over each other. Counsel, let me ask this question. So Justice Harlan's dissent in Plessy, what do you do with that?
Your Honor, we would say that...
Maybe your partner can answer this one so we can keep a good balance.
All right. Your Honor, we believe that Justice Harlan's dissent in Plessy would actually further our position insofar as Plessy v. Ferguson was an example of a law which directly harmed minority groups. We believe that the real question in Plessy was not whether or not discrimination was acceptable, but whether or not segregation constituted a form of discrimination. We don't think that's directly related to the case at hand.
Harlan says that the Constitution is colorblind. That would seem to be in tension with what you're saying. You're saying the Constitution can consider color if it's helping minorities.
Yes, Your Honor. Insofar as Justice Harlan does not believe that race can ever be used in any context in admissions, we believe that Justice Harlan was erroneous, and that, in fact, the framers of the Constitution did believe that race could be used in certain contexts.
Now, to maybe push the point a little further, Justice Harlan was discussing in Plessy the status of the free Blacks. Do you also know about the part of the opinion where he discusses Chinese people? Are you familiar with that part?
I'm a little bit familiar. Could you specify what exactly?
Harlan actually goes out of his way to say that people of African descent are citizens of the United States and they're in our community. And then Harlan says in the passage that people usually forget about that Chinese people are different, that they can never be assimilated, and that they can't fit into our society. So how might that affect your reading of the Harlan opinion? I think it actually might help you. I don't know.
I think it suggests that Justice Harlan's opinion is evidence for why, contrary to what certain individuals might say, the affirmative action policies can be extended to other minorities and not just African Americans, because we can see that kind of structural discrimination has existed against other minorities as well.
So what about, so your friends on the other side give you statistics, this high about Chinese and Asians and Japanese, Koreans and Vietnamese, other Asian Americans, that there's a disadvantage to them. How do you respond to those arguments, please?
We are considering mainly, we're not saying that no minority groups can be harmed. It's a little bit of a subtle distinction, Your Honor, between no minority groups may be harmed and the group that is harmed may not be a minority group. So the group that is harmed against in UNC's admissions policies and most affirmative action policies will be a broad group of people across races, mostly white and Asian individuals. And that group as a whole is not a minority group. And this is relevant because it suggests that the group that's harmed has political power and therefore doesn't constitute a discrete and insular minority that needs special protection against the political process from the courts. Because
I have to just push back. I mean, I know you want to overrule Grutter and Bakke, but there's a pretty big body of case law premised on the benefits from diversity. And I don't hear you saying those words at all. Everything you're saying is about political power and political process. What role do you see for the educational benefits from diversity to play in your argument?
Your Honor, this is why we would apply the intermediate scrutiny standard. There's absolutely no doubt that the admissions policies today, as well as admissions policies across the nation, would pass. Diversity, including racial diversity, is certainly an important government interest. And using the numerous academic and social benefits of a diverse academic class are well attested to in sociological studies. The military benefits of a diverse officer class are likewise undisputable. Furthermore, using race as a factor in admissions, as UNC does, for example, as one of the many factors in a holistic process, is narrowly tailored to achieve the goal of increasing campus diversity. In other words, even if we were to keep Grutter and Bakke, which we would not contend, this would still pass.
Well, let me ask the question a little bit differently if I can. Justice O'Connor wrote in Grutter, there's a 25-year clock. Whether it was holding or dicta, we can argue about it forever. But under your argument, it seems there's no logical stopping point. That is, so long as there are minorities who lack political process power, they will always receive these benefits. Is that your position? Affirmative action today, affirmative action tomorrow, affirmative action forever?
Not quite, Your Honor. We believe that minorities only need affirmative action because of the residual effects of discrimination. We don't believe there's some sort of ontological difference that stops minorities from excelling as much as white or Asian students. And therefore, we believe that if it were the case that minority students were performing at the same level as white students, for instance, there would no longer be an important government interest to further their
say the same level,
diversity.
Referring to how are we measuring same level?
I think this would have to be determined using the intermediate scrutiny standard, as we said. So the more similar the performance academically, financially, and socially.
SAT, we're talking about income, and what are we talking about here? We think similar.
I think it would be most appropriate to consider all of those, but certainly academic standing would be for first and foremost. So things like SAT. So if we were to see that minority groups like African Americans and Latinos were performing at the same level as white students, then there would be much less of an important government interest in furthering their performance for the purposes of diversity. And so it would be much less likely to pass the intermediate scrutiny standard.
Let me ask a question. Justice Gustafson, go ahead. I think you were about to, yeah.
Yeah, forgive me if I misstate your argument, but it seems like this is trying to right some social wrong. So is there a point where Asian students begin to underperform that this level of intermediate scrutiny would then begin to help their admission? It doesn't seem as concrete as a strict scrutiny standard.
Yes, Your Honor. There's nothing special about the current way the races happen to be performing. So if it were the case for whatever reason that Asian Americans were way underperforming white students, for instance, then this standard would allow for the government to step in and help Asian American students, or if another group of students that were a minority were underperforming. So if there's a minority group that is underperforming, Your Honor, we believe that it is acceptable for the government to increase diversity by helping them in the admissions process within a holistic process, of course.
Well, I may be mistaken, but I'm fairly certain that Asian students score higher in almost every metric in academics than white students. Should white students then get a slightly lesser bump than other students just because of the ratio that they are related to their academic success?
Not quite, Your Honor. So I think perhaps I misunderstood your question. I was wondering if you were asking a counterfactual question if Asian American students were to fall behind. But in the status quo, the reason white students, affirmative actions programs may not benefit white students while they may benefit minority students, just because, as we said before, benefiting a majority group like white students would be in turn disadvantaging other minority groups, which would not be allowed and would be subject to strict scrutiny.
Kind of like a policy question. Doesn't this create kind of a what Justice Scalia called a debtor creditor race, where there's always going to be some races that are considered burdened and other races considered burdeners? I mean, doesn't just are we all just Americans here, to quote Justice Thomas?
Yes, Your Honor, and we would like to have that reality achieved in actuality. We would like to see that people of different races can actually have the opportunity to perform at the same level, and currently they're unable to do so. We believe the best way to do that is to have government policies that allow for their flourishing.
Okay, I think your time is up. Thank you, Counselor. 5 minutes for the petitioners, whenever you're ready. Go ahead, please.
Respondents back away from Grutter's holding, which speaks volumes. They say minorities only need affirmative action because of discrimination, claiming that if minorities performed at the same level as whites, affirmative action could end. But they provide no clearly defined metric to determine this, which risks affirmative action existing in perpetuity, which is fundamentally contrary to the nature of Grutter. Respondent argues.
Oh, sorry. Respondent further argues that the court should only apply strict scrutiny to policies that disadvantage discrete and insular minorities. This ignores the context of this case. Asian Americans are minorities who have been historically discriminated against, from Chinese exclusion to Japanese internment, and the record demonstrates that UNC's policies are discriminatory against them. Respondents have distorted the precedential record in claiming that Bakke is the only case where the court applied strict scrutiny to a classification that did not involve a discrete and insular minority. Their approach requires the reversal of parents involved, Croson, Adirond, and many other cases. Further, Metro Immediate versus FCC, which the respondents cited to support their position of permitting discrimination that helps minorities, is no longer good law and should not be considered as such by the court. It was overruled in Adirond. And further, legislation need not discriminate against a discrete and insular minority under Caroline products to trigger strict scrutiny.
Right, but let me if I can push back for a few moments. Right. No, I think you're right about FCC Metro Media. That was this brief period where the court perhaps was going one direction. It was a very fragmented opinion. And it seems the court in Adirond, another case, went the opposite direction. But I think they do have a fair point, right? Even 150 years after the Reconstruction period, there's still inequality in this country. And it's really the role of the Supreme Court to tell these state universities with a history of awful policy at UNC, no, you cannot do what you can to make a more equal society. How can this court make such a ruling given the history we see in front of us?
I think in examining that question, we need to look at what the Grutter opinion actually said about racial preferences. So page 432, 433 of the opinion, right where the 25-year limit is discussed, the opinion specifically talks about the importance of race-based policies having a logical endpoint, saying that these policies should be in service of the goal of equality itself, not existing just in perpetuity. So the fact that those disparities still exist, and they could exist for long beyond the 25-year limit of Grutter, just proves that Grutter failed in its central mission, which is not a reason to extend it in perpetuity.
But what about the political process arguments they put forward? I mean, you can pick up any newspaper in this country, or at least swipe in any news feed, and you can see that some minority groups do have it a little bit worse off than others. And why can't the state take action to remediate that?
Your Honor, the state can, of course, take action to remediate the particular offenses, hardships, or by removing unjust policies, providing more relief to impoverished communities, et cetera. But the important distinction here is that the state may not do so on the basis of race. If the state is to provide aid to assist the disadvantaged, it must do so without regard to the color of their skin.
Right, but again, I think we're sort of dancing around the issue. Let's say we do everything we can based on socioeconomic whatever, and we still wind up with classes that are all white and Asian. Is that really where we want to be as a country? Is that who we are?
I think that the simulations we've demonstrated below.
Simulations are wrong. Simulations can be wrong.
Simulations are wrong. Assuming the simulations are wrong, certainly that is not where we want to be as a country, but simultaneously we don't want to be existing as a country where there's a creditor and debtor race in perpetuity. Racial affirmative actions have also had significant negative consequences, creating a system in which Asian American high school students, specifically, there's a whole industry for them to mask their interest in STEM fields, as we demonstrate in their brief. So affirmative action comes with stigma. Stigma Justice Thomas has talked about extensively in his post-graduating from Yale Law. It creates a system in which any minority who has achieved has their accomplishments questioned.
Then we have Justice Sotomayor, another member of the Supreme Court, who takes quite a different position on these issues.
Our argument is that respondents' consequentialist approach is not consistent with the 14th Amendment of the Constitution, and flies in utter contradiction of this court's case law, which has a clear defined equal protection framework of strict scrutiny for race-based classifications in all circumstances, demonstrated by Crozin, Adarand, and parents involved.
For these reasons, racial preferences are clearly in violation of the 14th Amendment. We urge the court to overrule Grutter, find state affirmative action unconstitutional, and therefore vacate and reverse the judgment below.
All right, thank you so much, Counselor.
Thank you.
All right, if the other team come back, I think that was one of the best rounds we've had all day. That was really strong. Both teams were really strong. I'll give some feedback, and I'll call on Dan, but I'll give some sort of general feedback. You were both teams were so well poised. Nothing we said rattled you. Everything was yes, Your Honor, no, Your Honor, right? Everything was very respectful, very deliberate, very calm. I deliberately asked you questions trying to get under your skin. I mean, I'm not a mean person. Maybe I am. I don't know. But I'm not trying to, be a mean person. But I was trying to see how you would phase, and you didn't flinch. Asking you questions like, "Are you okay with the entire university being white and Asian?" That's not a fun question to answer, and I think you handled it respectfully. It's not what I care about. It's what the Constitution requires. I asked, for the other team, does this mean affirmative action today, affirmative action tomorrow, affirmative action forever? I don't know if you got the reference, but there was Senator George Wallace famously said, segregation today, segregation tomorrow, segregation forever. It's a terrible joke, but I was trying to sort of flip that. And you're like, we're not there yet, and we can recess later. I thought that Kevin and Maxwell, even though you're not in the same building, you're in the same state, I thought your handouts were pretty smooth. And I think your transitions were actually smoother than people who were even sitting next to each other. So that's something I'm sure you practiced. I think for Aaron and Colin, I have to admit, I didn't read your brief before the argument. I'm sorry. And you can't always expect the judges to have read your brief. So at first I was like, wait a minute, do we have two respondent teams? I don't know if you had the same reaction, Dan. But I was like, wait a minute, what's going on? And then like, oh,
it took me a while, but now I remember the brief. I'm like, oh yeah. But I started hearing like, we want to overrule this, overrule that. I'm like, whoa, wrong side. But
yeah, no, Daniel and my other RA, Abby, graded the briefs over the Christmas break. So I hadn't seen the briefs before. So to be completely candid, so I was like, wait, what? I was actually messaging Daniel, like, I think we have a glitch with the schedule. We have two respondent teams. And I was like, oh, that's their argument. So that's my general feedback. I'll let Daniel go first, and then I'll come back with some more personal, some more personalized comments.
Yeah, that was a great round. I was almost getting a little frustrated there because I was trying to find the little things to ask questions about, but you would immediately clarify, and I couldn't get my questions out. So very good job. All four of y'all have a great prose about you that commands, attentiveness, if that makes sense. So great job responding to some seriously hard questions that Professor Blackman gave you. And I'm very impressed, guys. Good job.
All right, so let me give some feedback. So I'll start with Colin and Aaron. Because your position is so unusual, it's not, I'm not saying it's wrong. I think it's creative, but it's not what the judge is going to be expecting, right? So you'll have other judges in future rounds, right? If you advance, I would sort of lead off and say, how do I put this? We're approaching, we would recommend that the Supreme Court reconsider Grutter and Gratz and Bakke because they didn't, I'm trying to see how I can do this. I mean, here's my difficulty, right? And I'll be completely candid. In order for the Supreme Court to overrule precedent, you have to ask them to overrule precedent, right? And this is not your fault because you're not actually litigating the case. But Harvard and UNC have not asked the Supreme Court to overrule Bakke, and Harvard and UNC have not asked the Supreme Court to overrule Grutter and Gratz, right?
I think I emailed you like earlier on in the year. We could make an argument.
Yeah, and I'm sure I said you can, right? So you're not bound by it. But what I'm trying to figure out how to do is put on notice the judges that you're making sort of unconventional argument that is not what they're going to be expecting. So I would say something like, Your Honor, we realize that the briefing did not. Here's what I would say, Your Honor, we realize that there's not been a formal request made to overrule these cases, but we think that the court could put its equal protection jurisprudence on a sounder footing if they revisit these aspects of Bakke and revisit these aspects of Grutter. How's that sound? That sound okay, Daniel?
Yeah, I think, yeah, you don't ever want the judges to be sitting there kind of confused what you're asking for.
Like for 30 seconds, I was like, oh my God, what's going on? Like I thought I screwed the schedule and put two petitioner teams against each other. They pull up your brief, like, oh, wait, they're both the respondents. Okay, so this is recorded, so you can watch it later. But I would try to, your first 15 seconds or so, put the court on notice that it's correct, that there's not been a formal request made to overrule Grutter and Bakke, and just be honest, because that's true. But you think that there's a way to put the court's equal protection jurisprudence on a more sound footing, or something like that. Find like a way of saying it, and maybe not even overrule Grutter and Gratz. I mean, you said that in your brief, but like just to maybe reconsider how those cases are interpreted. Like you can sort of package it differently. And if they say your brief says a rule, like yes, we think you should overrule it. And if the judge says, it won't be me, it might be someone else who's judging in the future on. The judge says, well, counselor, did you ask the court to overrule Grutter and Bakke? You can say, if you're a smart ass, you could say, well, Your Honor, sir, the counsel at that stage should not make that request. Because obviously you're not you're not the lawyers. Or you could say, Your Honor, we realize this request was not formally made, but we're asking for it now. And at that point, I think the judge will get the idea that in other words, you're aware of the posture of the case as unusual, and you're working to deal with it. So, and then for Aaron, again, so I'll come back to the other teams in a moment. For Aaron and Colin, I would say straight up, we're looking to reinvigorate Justice Stevens's, was it from, what case did Stevens say this? And I can't remember. Was it, he did his Adirondack concurrence, I think, but he said it before another case. Do you remember? He had this line in Adirondack that there's a difference between a welcome mat and a no trespassing sign. Do you remember that line? Anyway, so I would say straight up that we're looking to embrace Justice Stevens's position, in which beneficial racial classifications are afforded intermediate scrutiny, while harmful racial classifications are afforded strict scrutiny. I would just say that in your first 20 seconds. So first 20 seconds, you're saying, look, that we realize that these precedents were not being asked, so we were ruled, but we want to reconsider them, and it's exactly what we want to reconsider. Once you say that, you're on a much stronger foundation. Because to be completely candid, that argument is so much better than the diversity stuff, right? The diversity argument, maybe you disagree, I don't know, Max and Kevin, what they think, but the diversity argument has always been very weak in my mind, right? It's just always been, if you actually look in today's New York Times Magazine, I don't know if you saw, there's a long article about Justice Powell, who was this old crusty white dude who said the reason why we need affirmative action is because of diversity, and that's been the rule for 50 years. And I know why you made the strategic choice. You probably recognize this is not a very good argument, or maybe I don't know that, but you made a choice. That's your strategy, and you're sticking to it. You might also, again, for Aaron and Colin, bring in Justice Thurgood Marshall's dissent or a concurrence or partial concurrence in Bakke, where he basically says, for 500 years or 400 years of servitude, you can't just turn off on a dime. So I think that sort of reinforces your position on political power. I think you handle the Asian American issue well. I mean, I'm just looking at you guys, I'm guessing you're Asian American. So I think there is kind of an optics issue there where that does kind of help you, right? Because you didn't do this, I'm glad, is you say, well, personal experience. See, look at us, we're Asian, we're doing just fine, right? Sitting there at Exeter Academy, right? But I think you were very good at saying statistics and these other societal things. That was good. All right. For Kevin and Max, I thought you had a really good command of the cases. You said all the right cases, and then you got them on the Metro Media, which is not good law anymore, right? I don't know that Metro Media ever had a 5-member majority. It was a very fractured opinion. And it's sort of hard to make heads or tails of that case. And even if there was Metro Media, it was in the context of, I think it was of an FCC license for telecommunications that may not extend to higher ed. So, but I think you responded well on that point. I think you also had a good grasp of the Reconstruction legislation. You anticipated my question. You came right out saying this was about slavery, not race. So you sort of anticipated that was very strong. I also thought that you handled my question about what happens if the entire campus is lily white and Asian kids, right? That's not an easy question to answer. It's not a pleasant question to answer. And I thought you handled it mature and calm. You didn't get sort of agitated at me. It's like, what are you talking about? You handled it calm. I thought both teams had very good pacing. Your diction was clean. I didn't have any trouble understanding you. And I think you answered just about every one of my questions. To Daniel's point, I don't think I stumped you once. Maybe I didn't, I forgot, but I don't think I actually stumped you. Other teams I stumped, but I didn't really stump you. Whatever I asked you, you knew, or at least you gave me something good enough to pretend you knew. And that's good enough for me. You're not always going to know an answer 100%, right? But you have good enough to get there. So when you both did very well, go back and watch this video again, and you're going to say, oh, I should have said this, and I should have said that, and you'll beat yourself up 100 times, but just be very proud of yourselves. Because I know, for Max and Ken, what are you, sophomores, juniors, seniors? What year are you all?
I'm a junior.
I'm also a junior.
And my friends in New Hampshire, what year are you?
He's a senior and I'm a junior.
Okay, so look, you're 16, 17 years old. You're performing well beyond your years. You're doing, I mean, this could have been a semifinal round for law school moot court. Daniel, am I exaggerating?
No, not at all.
This could have been like teams that advance in a law school moot court. We'll see how you guys do next time if you advance, but this was very impressive. So I have no more feedback. Do you have questions for me or for Daniel?
I think I'm good. Thank you for all your feedback, though, and great job, respondents.
Oh, no.
Thank you. Great job to you as well.
I just had a question about how the next rounds work. Will that be like an email soon?
Yeah, so I have actually one more round at 4:00 or time. So basically about 40 minutes, another round. Then we'll assemble all the grades, we'll average them out, and probably tomorrow, maybe Friday. I don't know how late it's going to go, but by tomorrow, Friday, I'll send an email. 8 teams will advance, so 4 petitioner and 4 respondents. And by the way, both of you teams can advance. It's done on points, so it's not like you're not actually. I mean, you're competing against each other, but not really, right? So it's both of your team, but both of you can advance the next round, and the next round will be, I think, on the February. I think I said the 27th and April. I'm sorry, February 27th and April 1st. Those will be the next rounds. I'm sorry, not April, March. I'm sorry. February 27th and March 1st. So there'll be a Monday and Wednesday, the same deal. And there'll be 4 petitioner teams and then 4 respondent teams. So the top 8 teams.
Thank you very much.
Thank you.
All right.
Thank
Well done, petitioner. It's very good
Interest
case.
in law school, or is that an interest that some of you have?
Definitely.
I'd love to go to law school. Yeah.
Yes, me as well.
Oh, that's good to hear. I think you all have very promising careers. If you're ever in Houston, come by. You're always welcome to sit in my class. Or if you have any questions, you know how to get in touch with me. I'm always happy to answer any questions you have. Okay?
Yeah, I just had a quick question. Like, this isn't really about the case, but I was just wondering if you know someone named Ward Farnsworth.
I know. Yeah.
Yeah, okay.
He's one of our friends' dads.
Yeah, so there was of our school, a senior when I was a freshman. Yeah, he was his dad.
Oh, really? Yeah, he was the dean at University of Texas Austin until fairly recently.
Mm-hmm.
Oh, I'm sure if you want to check out UT Austin, I'm sure he'll give you a tour. Okay, excellent.
Thank you very much.
You.
That's why if the students can sign off, I'll talk to Daniel for a few moments and we'll put your grades in and then we'll be in touch for tomorrow. Thank you so much.
Thank you, judges.
Thank you.
Take care.
Thank you.
Thank you, judges.
Thank you.
I stop the recording. One moment, Daniel.